At 9:47 a.m. Eastern Time, the 9 justices of the nation's highest court delivered a ruling that no one saw coming. Not the legal experts who'd been analyzing the case for months. Not the politicians who'd been preparing for every possible outcome. Not even the president who sat in the Oval Office, phone in hand, waiting for news that would determine whether his presidency survived the next 48 hours. The decision was unanimous. That alone was shocking in an era of 5-4 splits and bitter ideological divisions. But what the justices said in their 73-page opinion would ignite a constitutional firestorm that threatened to tear the country apart. And President James Donovan, the man at the center of it all, had exactly 72 hours to respond before everything he'd built came crashing down. To understand how we arrived at this moment, we need to go back 9 months to a decision President James Donovan made that seemed routine at the time, but would eventually land him before the Supreme Court in the most consequential case of his presidency. President Donovan was a political pragmatist, a former business executive who'd won the presidency on a platform of common sense solutions and getting things done. He wasn't an ideologue, wasn't particularly interested in constitutional theory or legal philosophy. He saw government as a massive organization that needed efficient management, and he approached the presidency the way he'd approached running a Fortune 500 company, with a focus on results over process. The issue that would eventually bring him before the Supreme Court began with an executive directive he issued in March. Congress had been deadlocked for over a year on critical infrastructure legislation. The country's bridges, roads, and transportation systems were deteriorating, but political divisions made any major spending bill impossible to pass. Frustrated with congressional inaction, President Donovan decided to act unilaterally. He issued what he called an executive infrastructure initiative, using a combination of existing executive authorities, emergency declarations, and creative reinterpretation of decades-old statutes to authorize over $200 billion in infrastructure spending without congressional approval. His legal team had crafted an argument that technically each individual action was within presidential authority. Together, they added up to something unprecedented: a president essentially appropriating funds and directing major domestic policy without legislative input. The reaction was immediate and fierce. Constitutional scholars called it executive overreach. Opposition leaders filed lawsuits within hours. Even some members of Donovan's own party expressed concern about the precedent being set. But the president was defiant. "I was elected to solve problems, not wait for a dysfunctional Congress to get its act together," he declared at a press conference. "If they won't do their job, I'll do mine." The case moved quickly through the courts. A federal district judge initially blocked portions of the initiative, ruling that the president had exceeded his authority. The administration appealed, and an appellate court partially reinstated the program while acknowledging serious constitutional questions. Within 6 months, the case reached the Supreme Court. What made this case extraordinary wasn't just the constitutional issues at stake, it was the timing. The Supreme Court term was unusual that year. Chief Justice Raymond Blackwell, a moderate appointed 15 years earlier, had announced his retirement effective at the end of the current term. His replacement had already been nominated by President Donovan and was awaiting Senate confirmation. This created a strange dynamic. Blackwell knew he was hearing his final cases and seemed determined to leave a legacy that transcended partisan divisions. The other 8 justices were split predictably along ideological lines. 4 conservatives, 4 liberals, all appointed by presidents from their respective parties, all with well-established judicial philosophies. Court watchers assumed the case would come down to a 5-4 decision, with the swing vote determining whether Donovan's initiative survived or was struck down. No one anticipated what actually happened. What the public didn't know during the months of oral arguments and deliberations was that something unprecedented was happening behind the closed doors of the Supreme Court. Chief Justice Blackwell, facing his final major case, had begun a quiet campaign to achieve something that seemed impossible: unanimous consensus on the most divisive constitutional question in a generation. Blackwell was a fascinating figure. Appointed by a moderate president during a rare period of relative political civility, he'd spent 15 years trying to steer the court toward narrow rulings that avoided sweeping constitutional pronouncements. He believed in judicial restraint, in deciding cases on the smallest grounds necessary, in preserving institutional credibility through moderation. His critics called him timid, his defenders called him wise. But this case was different. Blackwell recognized that a 5-4 ruling, regardless of which way it went, would be seen as purely political. If the conservative justices sided with the Republican president, it would look like partisan protection. If they ruled against him on a close vote, it would appear to be ideological opposition. Either outcome would further erode public trust in the court as an institution above politics. So Blackwell did something extraordinary. He began holding private meetings with each justice individually, conversations that went far beyond the usual deliberations. He wasn't lobbying for a particular outcome. He was lobbying for unanimity itself, arguing that the court's institutional credibility demanded they find common ground. Justice Sarah Chen, one of the liberal justices, later described these conversations in her private journals, which wouldn't be published until years later. "Raymond came to me," she wrote, "not as Chief Justice, but as a colleague concerned about the future of the court. He said, 'We're at a crossroads. We can issue another party-line split decision and watch our legitimacy erode further, or we can show the country that law still exists above politics.' I told him I thought he was being naive. He said maybe so, but he had to try." What made Blackwell's quest even more remarkable was that he was asking the justices to do something genuinely difficult, not just to agree on a result, but to craft reasoning that all 9 could sign on to. This meant finding a legal theory that could satisfy both the textualist conservatives and the more flexible liberals, that could address presidential power without creating precedents that would haunt future administrations, that could be principled without being political. The deliberations stretched on for weeks longer than usual. Blackwell circulated draft after draft, each one attempting to thread impossible needles. The conservative justices wanted clear limits on executive power. The liberal justices wanted protection for congressional authority. Everyone had their own constitutional red lines that couldn't be crossed. Meanwhile, President Donovan was becoming increasingly anxious. His staff monitored every signal from the court, tried to read meaning into the extended deliberations. Some of his advisors urged him to prepare contingency plans for an adverse ruling. Others insisted he should publicly defend his actions and prepare to challenge a negative decision. The president's attorney general, Marcus Holloway, a brilliant lawyer who'd argued the case before the court, told Donovan something that stuck with him. "Mr. President, the longer they deliberate, the more likely we're looking at something none of us anticipated. The court doesn't take this long just to issue a predictable ruling." He was right, but not in the way anyone expected. The morning the decision was scheduled to be announced began like any other Supreme Court decision day. Legal reporters gathered in the courtroom. The justices took their seats at 10 a.m. sharp. Chief Justice Blackwell, looking more tired than usual but with an expression of quiet resolve, announced that the court would be delivering its opinion in Donovan v. United States. The courtroom went silent. This was the case everyone had been waiting for. Justice Thomas Hartford, the most senior associate justice, would normally have read the majority opinion if Blackwell was in the minority, but instead, the Chief Justice indicated he would be delivering the opinion himself. That was the first surprise. It suggested Blackwell had written the majority, which could mean anything given his unpredictable record. "This case," Blackwell began, "presents fundamental questions about the separation of powers and the limits of executive authority in our constitutional system. After careful deliberation, the court is unanimous in its judgment." The word unanimous caused an audible gasp in the courtroom. Legal reporters immediately began typing. In the gallery, members of Congress who'd come to hear the decision looked at each other in shock. Unanimous? How was that possible? Chief Justice Blackwell continued, reading from the opinion with measured precision. The legal reasoning was intricate, but the core holding was clear. President Donovan's executive infrastructure initiative had indeed exceeded constitutional authority. The president could not, through creative combination of existing statutes and executive powers, appropriate funds and direct major domestic policy without congressional approval. But here's where it became extraordinary. The court didn't stop there. In language that was unusually direct for a judicial opinion, the justices went further, addressing the underlying crisis that had led to the president's actions in the first place. "We recognize," Blackwell read, "that this case arose from a genuine failure of governance. Congress has been unable to fulfill its basic legislative responsibilities on matters of critical national importance. While this dysfunction does not justify executive overreach, neither can it be ignored. The Constitution provides mechanisms for addressing governmental deadlock, and this court has a duty to speak to those mechanisms." What followed was unprecedented. A Supreme Court opinion that essentially called out both the president and Congress for their failures, while establishing a new framework for understanding executive power in an era of legislative gridlock. The opinion laid out 3 core principles. First, Executive authority in domestic policy is inherently limited and cannot be expanded through creative statutory interpretation when Congress has explicitly failed to act. Second, congressional dysfunction does not create a constitutional emergency that justifies presidential unilateralism. Third, and this was the bombshell, when governmental deadlock threatens national interests, the political branches have a constitutional duty to find mechanisms for resolution, and courts may, in extreme circumstances, compel them to do so. That third principle was what made every constitutional lawyer in the room sit up straight. The court was suggesting it might have the power to force Congress to vote on critical legislation if deadlock threatened constitutional governance. It was a radical theory, one that would require years of legal development to fully understand, but the mere suggestion was revolutionary. Chief Justice Blackwell paused before reading the final section of the opinion. The court is acutely aware, he said, that this decision will be criticized from all sides. Some will say we've been too deferential to congressional dysfunction. Others will say we've been too harsh on executive initiative. But we are unanimous in our conviction that the Constitution requires more from all branches of government than what we have recently witnessed. He looked up from the opinion, making eye contact across the courtroom. The president's initiative is struck down. But this court also puts Congress on notice that continued failure to legislate on matters of urgent national importance may itself raise constitutional concerns. We remand to the lower courts with instructions to monitor whether the political branches can resolve the underlying issues through proper constitutional means within a reasonable time frame. As Blackwell finished reading and the justices filed out, the courtroom erupted in controlled chaos. Reporters rushed to file stories. Legal analysts tried to process what they just heard. Members of Congress sat stunned, realizing they'd just been given a judicial warning shot. Back in the White House, President Donovan watched the decision being announced on television in the Oval Office. His chief of staff, Andrea Walsh, sat beside him, along with Attorney General Holloway and several other senior advisors. As Blackwell read the opinion, Donovan's expression shifted from concern to confusion to something approaching shock. He began, then stopped, trying to process what he'd heard. Did the court just strike down my program while also threatening Congress? Yes, Mr. President, Holloway said quietly. They did exactly that. Is that even legal? Can the court do that? That's going to be debated for years, but they just did it, unanimously. The president stood and walked to the window, looking out over the rose garden. His staff waited, unsure what would come next. Finally, he turned back to them. Get me the congressional leadership on the phone, all of them, within the hour. The hours following the Supreme Court decision were among the most intense of President Donovan's time in office. The media coverage was unprecedented. Every major network broke into regular programming to discuss the ruling. Legal experts offered wildly divergent interpretations of what it meant. Politicians from both parties scrambled to develop positions that would play well with their bases while acknowledging the unusual nature of the decision. The opposition party's response came first. Senator Patricia Morrison, the minority leader, held a press conference within an hour of the decision. This is a clear rejection of presidential overreach, she declared. The court has spoken unanimously, 9 justices, including those appointed by presidents of both parties, in defense of constitutional governance. President Donovan must accept this decision and work with Congress through proper channels. But when reporters asked about the court's criticism of congressional dysfunction, Morrison was less definitive. Congress represents diverse viewpoints across a vast nation. Disagreement is not dysfunction, it's democracy. The majority party's response was more conflicted. Speaker of the House William Bradford, from the president's own party, issued a statement that tried to thread multiple needles simultaneously. We respect the court's decision while noting its unusual commentary on legislative processes. Congress will continue to deliberate on infrastructure needs through constitutional means, as we have been doing. Behind the scenes, however, Bradford was furious. In a private call with fellow party leaders, he raged about the court inserting itself into legislative prerogatives. They just gave themselves permission to dictate our agenda, he complained. This is judicial activism on steroids. President Donovan, meanwhile, was making his own calculations. His legal team was clear. The decision was final and unanimous, meaning there was no credible basis for challenge or non-compliance. His infrastructure initiative was dead, but the political opportunity the court had created, intentionally or not, was significant. During a hastily convened cabinet meeting that afternoon, Donovan laid out his strategy. The The court didn't just rule against me, he explained. They ruled against business as usual. They've given us cover to demand that Congress actually do its job, and they've implied there might be consequences if deadlock continues. His chief of staff, Andrea Walsh, pushed back. Sir, with respect, the court also just humiliated you. Your signature initiative has been struck down unanimously. You need to show contrition, not belligerence. I need to show leadership, Donovan countered. The court said I overreached. Fine, I accept that. But they also said Congress has been failing its constitutional duties. I'm going to hold them to that standard. Attorney General Holloway, who'd spent the afternoon with his team analyzing every word of the opinion, offered a more nuanced view. Mr. President, this decision creates a unique moment. The court has essentially declared a plague on both your House and Congresses. You have an opportunity to reset the relationship, but it requires genuine compromise, not just tactical positioning. That evening, President Donovan met with congressional leaders from both parties. The meeting, held in the Roosevelt Room, was tense from the start. Everyone understood the stakes. The Supreme Court had just injected itself into the executive-legislative relationship in an unprecedented way, and how the political branches responded would set precedents for decades. The court has spoken, Donovan began. I accept their decision completely. My executive initiative is withdrawn. But let's be honest about what else they said. They told all of us, me, you, everyone in this room, that we've been failing the American people. Senator Morrison bristled. Mr. President, don't try to spin a unanimous rejection of your actions into some kind of shared responsibility. You overreached. The court corrected you. That's what happened. That's part of what happened, Donovan agreed. But read the opinion, Senator. Really read it. The court is warning that continued dysfunction might have constitutional implications. They're suggesting they might intervene if we can't figure out how to govern effectively. Speaker Bradford, despite his private anger at the court, saw the opportunity. The president has a point. The court just changed the rules. We need to respond in a way that shows we got the message. What followed was a remarkable negotiation. Over the next several hours, President Donovan and congressional leaders from both parties hashed out a framework for moving forward. It wasn't easy. Decades of partisan hostility don't disappear in a single meeting, but the court's decision had created something rare, a shared external pressure that made compromise politically viable. By midnight, they had the outline of a deal. President Donovan would formally accept the court's ruling in a televised address the following day, acknowledging that he'd exceeded his authority. In exchange, congressional leaders would commit to passing a bipartisan infrastructure bill within 90 days, using the court's timeline language as political cover for making concessions to reach agreement. It was Speaker Bradford who articulated what everyone in the room understood. The court just gave us all an excuse to do what we probably should have been doing anyway. We can blame them for forcing our hand, which lets us compromise without looking weak. The next morning, President James Donovan addressed the nation from the Oval Office. His speech was unlike anything Americans had heard from him before. No defiance, no spin, just a straightforward acceptance of the court's decision and an acknowledgement of his own mistakes. Yesterday, the Supreme Court unanimously ruled that I exceeded my constitutional authority, he began. They were right. In my frustration with congressional inaction, I convinced myself that creative interpretations of executive power were justified. I was wrong. The Constitution is clear about how major domestic policy decisions should be made, and I violated those principles. He paused, letting the admission sink in. Then he continued. But the court said something else, too. They told all of us in government, executive and legislative branches alike, that the American people deserve better than what we've been giving them. Deadlock is not a governing strategy. Dysfunction is not democracy. Donovan then announced the framework agreement with congressional leaders, committing to work through proper constitutional channels while Congress committed to action on critical priorities. This is how our system is supposed to work, he said, not through executive overreach, but through the sometimes messy, always difficult process of democratic compromise. The reaction to the speech was cautiously positive. Even political opponents acknowledged that Donovan had handled a humiliating defeat with unexpected grace. The media coverage shifted from president rebuked by court to president and Congress respond to historic ruling. But the real test came in the following weeks. Would Congress actually follow through? Would the bipartisan framework hold under pressure from partisan activists who opposed compromise? Would the president resist the temptation to engage in executive overreach again when the going got tough? Chief Justice Blackwell, watching all of this from his office at the Supreme Court, allowed himself a small smile. His clerks noticed he seemed lighter, less burdened. He'd accomplished what he'd set out to do: create a unanimous decision that transcended partisan divisions and potentially reset the relationship between the political branches. In a private conversation with Justice Chen, who'd initially been skeptical of his quest for unanimity, Blackwell reflected on what they'd achieved. "We can't solve the country's political problems from the bench," he said, "but we can create moments where the political branches are forced to confront their failures. Whether they take advantage of that moment is up to them." "Do you think they will?" Chen asked. "I'm cautiously optimistic," Blackwell replied. "We gave them cover to compromise. We made it politically viable to work together. The question is whether they have the courage to actually do it." The 90-day timeline the court had suggested became a countdown clock that the media obsessively tracked. Every day brought new coverage of whether Congress would meet the deadline, whether the fragile bipartisan coalition would hold, whether President Donovan would interfere or facilitate the process. The negotiations were difficult. Multiple times it seemed like the whole framework would collapse over disagreements on funding mechanisms, project priorities, or partisan riders that one side or the other tried to attach. But every time deadlock threatened, someone would invoke the court's decision, the implicit warning that continued dysfunction might bring judicial intervention. On day 87, 3 days before the deadline, Congress passed the Infrastructure Investment and Renewal Act. It wasn't everything anyone wanted. The progressives thought it didn't go far enough. The conservatives thought it spent too much. Regional interests fought over project allocations. But it was a comprehensive bill that addressed real needs and had genuinely bipartisan support. President Donovan signed it in a Rose Garden ceremony attended by congressional leaders from both parties. In his remarks, he was explicit about the journey. "This bill exists because the Supreme Court forced all of us to do better. I'm not proud that it took a unanimous rebuke to get us here, but I am proud that we responded to that rebuke by showing the American people that their government can still function when we put country over partisanship." The Supreme Court decision and the political response it generated had effects beyond just infrastructure policy. In the months that followed, Congress and the president negotiated compromises on several other long deadlocked issues. The spirit wasn't one of warm cooperation. Partisan differences remained sharp, but there was a recognition that the court had changed the calculus around dysfunction. Chief Justice Blackwell retired as scheduled at the end of the term. In his final opinion as chief, a minor case about administrative procedure, he included a footnote that legal scholars would dissect for years. It read, "The court's role in our constitutional system is not to govern, but to ensure that governance remains possible within our foundational framework. We serve democracy best not by making decisions for the political branches, but by holding them accountable to their constitutional duties." President Donovan's presidency was fundamentally altered by the Supreme Court decision and his response to it. His approval ratings, which had been mediocre before the ruling, actually improved in its aftermath. Voters appreciated the humility of his acceptance and the effectiveness of the bipartisan accomplishments that followed. He won re-election 2 years later, running on a platform of tested leadership that explicitly referenced the court decision as a turning point. But there were also costs. The constitutional theory the court had suggested that judicial intervention might be appropriate if political dysfunction threatened governance created anxiety across the political spectrum. Conservative legal scholars worried about judicial activism. Progressive activists feared courts might use dysfunction as an excuse to override legislative prerogatives. Years of litigation followed as lower courts tried to apply the Supreme Court's reasoning to other cases. The infrastructure bill itself, while successful in passing, faced implementation challenges. Not all projects were well designed. Some funding was wasted. Political battles continued over who got credit and blame for various outcomes. It was messy, imperfect, and very human. Exactly what democratic governance looks like when it's actually working. The Supreme Court's decision in Donovan versus United States stands as one of the most consequential rulings of the 21st century, not because of the specific legal holding, presidents cannot circumvent Congress through creative executive action, but because of what it revealed about the fragility and resilience of democratic institutions. Chief Justice Blackwell's quest for unanimity, his conviction that the court's credibility depended on rising above partisan divisions on the most important questions, created a moment where change became possible. President Donovan's decision to accept defeat with grace rather than defiance, to use the court's rebuke as an opportunity for reset rather than as an excuse for grievance, demonstrated that political leadership still mattered. And Congress's ability, however imperfect and grudging, to actually legislate when given both pressure and cover to do so, showed that the system could still function when the incentives aligned. But perhaps the deepest lesson was this: constitutional crises don't always announce themselves with dramatic confrontations or revolutionary changes. Sometimes they come disguised as routine dysfunction, as normalized failure, as the slow erosion of expectations about what government should accomplish. And sometimes the solution isn't a radical reimagining of the system, but simply insisting that the system we have actually works the way it's supposed to. That morning, when the 9 justices delivered their unanimous message, they weren't choosing sides in a political battle. They were reminding everyone, President, Congress, and citizens alike, that the Constitution isn't self-enforcing. It requires people in positions of power to actually believe in something beyond their own immediate interests. President James Donovan learned that lesson the hard way in a 73-page opinion delivered by 9 justices who, for one brief moment, spoke with a single voice. Whether that lesson endured beyond his presidency, whether it created lasting change, or just a temporary interruption in partisan warfare, would depend on choices not yet made by leaders not yet elected. But for that moment, the system worked. Imperfectly, messily, and only after being forced to by the court. But it worked. And in an era when faith in democratic institutions hung by a thread, sometimes working imperfectly is revolutionary enough.